Good afternoon. This is the lecture for Chapter 5, the courthouse for the America's Courts in the Crim 4 class. Again, as a reminder, if you haven't already, I would suggest that you print out the Chapter 5 PowerPoint, follow along, because that's where this lecture is based off of. And then you can utilize that PowerPoint to highlight as well as write notes within the areas that and I'll make suggestions on areas that you need to concentrate on specifically for the exam. All right, courthouse. So a lot of people, if you look at the courthouses or like TV, you'll see that perception and reality are pretty far removed. Although there are some similarities there, the actual realities of the courtroom in practice don't mimic what you see on TV and in the movies. Early American courthouses were pretty simple structures, but by the mid 1800s, designs started incorporating formal architectural elements. And the reason why they did that was to give it a very imposing view. So people needed to have a little bit of I don't want to say fear, but for lack of a better term, let's just say respect for the court and courtroom process, and having an official, very intimidating building and structure kind of led to the idea that everything that went on within that structure was solemn and very serious in nature, and so that was what the government wanted to portray out to let people know that when decisions were rendered here, that they were rendered fairly and justly, and everything that goes on within the courthouse is pretty serious and solemn. Most courthouses are centrally located, obviously, in the cities to allow for easy access to everybody, or for everyone to have easy access to. That's primarily in the downtown areas in most cities. And there's a lot of support services that are around there. They'll have bail bonds, defense attorneys, bounty hunters, and then they'll have security services, and they'll have restaurants and bars and that kind of stuff. And they're primarily, they know that their clientele are going to be court staff, all the courthouse actors, and also people that come into court, witnesses, victims, as well as defendants and plaintiffs. So courthouses also maintain holding cells within the courthouse, and they'll transport. Generally, the courthouses are also right by the jails, and in the case of Fresno, that is the case. In the older designs, the inmates would be transported over and go into the same entrances as visitors and staff did, but now with the newer designs, they're keeping them hidden. And then here in Fresno, they actually go underground. There's an underground tunnel that brings them into the courthouse from the main jail and the north jail. I believe it's the main jail and north jail. I think, anyway, or it could be the old jail. So, but anyway, it does bring them underground, and so that way they're not seen. There's twofold reason for that. First, primary is safety and security. If the minute you bring inmates out into the open, there is a chance that they are going to wind up getting either broken out, or they can be injured. Cars going across. A lot of stuff can happen. But the other reason is they don't want people to see people, especially going in and out of the courtroom and the courthouse, wanting to see inmates being shackled and transported over chain gang style, because that's pretty much how they do it. Only because that's going to put the idea of guilt in their mind, especially if let's say you're a person who was selected to go in for jury trial, and you see these inmates, they're all being shuffled in. You're going to have your own biases, and those biases may lead to an unfair verdict, and so they try to minimize that. So that's one of the mechanisms for doing that. All right. So once you're inside the courthouse, you're going to have, you'll go through the entry, and when you go inside the entry, you'll find, like here in Fresno, they either wand you down, or you go through a metal detector. You'll have your stuff go through the metal detector. Some places don't do that. And then you'll see a lot of bustling activity, people moving back and forth in the hallways and in the lobbies, and they're pretty congested. Because there's a lot of, especially in these larger courtrooms, there's a lot of people that are going in and out of the courthouse and going in and out of different courtrooms. But if you take some time, you'll find that these lobbies, these hallways, actually act as secondary offices. So, and the reason or how they act as secondary offices is because these are where last minute conferences are held, where you may have a witness that's coming in to testify. You may have either the prosecution, defense, depending on who they're testifying for, kind of coaching them, telling them what to expect, some of the things that they need to refrain from saying, only answer the questions that are afforded, don't provide any more information other than what is being asked of you. So they give that kind of coaching. You also see communications between defense and prosecution with regard to plea bargaining. So hallways and lobbies and all the stuff within the courthouse itself, there's a lot of things that are going on in there. However, when you go into the courtroom, things change, right? It becomes really solemn and real quiet. It's not frantic like it is out there. Now, depending on the courtroom and how the judge, because the judge is the overseer, judge is the arbiter, the overseer of the entire courtroom. They're the ones who set the tempo and the permissiveness of interactions within the courtroom. So some judges are pretty liberal with regard to that. As long as you speak in hushed tones, they will allow attorneys to go and talk or talk with their client if they're a defense attorney, or talk with witnesses, as long as everything's in hushed tones, and they'll conduct their business on whatever case they're dealing with. Some judges don't like that. Some judges say, you know what, when you're in here, I'm dedicating, that's a distraction. I do not want distractions in my courtroom, and so I would like no one to be moving around, and so you need basically have your I's dotted and your T's crossed before you walk into my courtroom. In most courtrooms, the general design is you'll have the judge's bench. That'll be facing the entry doors, right? So on the opposite end of the wall, so you have the entry doors one side, judge's bench on the other facing, and so they have a full unencumbered view. Directly behind the judge, you'll have a door that goes into the judge's chambers. But in the case of in these larger buildings, that door will lead to a number of chambers and offices as well. So you'll have a hallway that leads, and that's pretty much how it is in Fresno and in the new courthouses in Madera. In front of the judge, in front of the judge's bench, you're going to see two tables. They're separated, generally, body width and a half or so apart, and those tables are for the plaintiff / prosecutor. Or the defendant defense. And they are in line facing the judge, generally. You'll also find in line with the judge's bench. So here's the judge's bench, and they kind of radiate, most of them just radiate out into a semicircle. You'll see a desk for the court reporter. You'll also see, in most cases, you'll see an administrative assistant that'll be there, that'll be processing the cases, handing cases over to the judge, completing either a minute order, basically those are the orders by the court, or an abstract of judgment, getting all that completed, getting papers that need to be signed, so on and so forth, so they can be handed to the bailiff for either the witness or the defendant or whoever. You'll also see a witness stand on one side or the other of the judge, and on the same side as the witness stand, you will see the court or the jury box, right? So if the witness stand is to the left of the judge, then you're generally going to see the jury box on the left of the judge, and if it's on the right, it'll be on the right. And the reason why they do that is because human beings are not just vocal animals, but we are visual ones as well. And so the jury should have an unencumbered view of anybody who's testifying in court to allow the jury to make a full observation and render a fair judgment based on what they hear and see within the courtroom. And, you know, they'll take into account if somebody's stammering or whatever, they'll be able to see what nervousness is. And so you can see these non-vocal cues, and those non-vocal cues give as much information sometimes as the spoken word. So, all right. So we're going to go through the different courtroom staff. There's 3 pages of courtroom staff. You'll have law enforcement inside the courts, such as court security staff, and they could be private security or sheriff deputies. You'll also see correctional officers that'll be transporting inmates from the jail to the courtroom and back into the holding cells as well. Sometimes the bailiff actually moves some of the holding cells over. Sometimes it's correctional staff. It just depends on the court itself. The bailiff is the actual peace officer who maintains order of the court. Most bailiffs are armed, but again, like I said before, some judges do not want their the staff inside the courtroom armed, and some of them are not armed. So that sometimes that can pose an issue for peace officers, but you know, you have to follow the rules of the court when you're in the courtroom. Obviously, there's going to be attorneys in the courtroom. You'll have a prosecutor, and you'll have a public defender, and or a private defense attorney. And some public defenders, and we'll get into public defenders later on down the line. Some public defenders are, what's the word I'm looking for? They are either public defenders or, in other words, are employees of the government, or they are contract employees. In other words, the government hires a law firm or law firms to render those services. And we'll get into some of the different types of defense attorneys later on in another chapter. Like you'll see correction staff, I said you'll see them earlier, but you may see probation officers or parole agents. And the probation officers, they generally provide pre-sentence reports to the court to assist the judge in rendering a fair sentence to the defendant. They also will have parole agents who will submit diagnostic reports, correctional staff and parole agents who submit 1170D diagnostic reports, and those are reports to the court to make a decision as to whether or not a person should be sentenced to prison or jail. So sometimes you'll see those staff in there. You'll also see a lot of pretrial service representatives. That would be from drug programs, anger management programs, and that kind of stuff. And those are primarily for sentencing and or diversion programs. And a diversion program is essentially what it sounds like. It's a program designed to allow the judge to divert a case away from the trial portion with the expectation that the individual engaging in the program will successfully navigate that program, and upon completion will have that case dismissed. So it's generally reserved for individuals that have really low-level criminal behavior or maybe first-time offenders with a low-level charge. All right. So some of the other personnel would be obviously the judge, and that is the person who presides over all activities within the courtroom. And you'll have a law clerk who performs all the legal research for the judge. They may not always be in the courtroom, but they provide all the legal research for case law and precedent, so that way a fair decision can be rendered. The clerk of the court, who is the record keeper responsible for summoning jurors, they will be in there. You'll obviously have a court reporter, and they're responsible for written transcription. You may have a secretary, and I said, generally speaking, you will, especially here in Fresno and in Madera, they have a secretary that's there, and they handle the routine paperwork that happens from these judgments and these orders, and they also assist the judge in maintaining the calendar of cases that have to come through and get adjudicated. You'll have translator that may be providing translation services. Now, a lot of courts, like here in Fresno, we have many translators, Spanish-speaker translators. But obviously, we have more than just Spanish-speaking people here in Fresno County, and so it would be cost prohibitive to maintain an official translator for all of the native tongues that we have in this county. So a lot of these courts will employ either an online service or a phone service that will provide translation services. You'll have a court administrator, and that person is much like a judge, where the judge presides over law and all activities within his courtroom or her courtroom. A court administrator provides or presides over all administrative tasks within the courthouse. So much of that would be like human resources, responsibilities, and other administrative tasks. They supervise other staff that are not being directly supervised by the judge. You'll have a docket clerk, but however, a docket clerk, they assemble case files, distribute legal documents to attorneys and judges. Sometimes, depending on the workload, the clerk of the court and the docket clerk are going to be pretty much the same person. So oftentimes those two will be combined. Obviously, you're going to have victims and you're going to have witnesses. You're going to have the defendant, obviously the person who's accused of the crime, or if it's a civil court, you'll have the plaintiff. And then you'll have bail agents who will be in a courtroom sometimes, media, witnesses. Obviously, you're going to have jurors when the case actually does go to trial. You might have different representatives for services for victims and witnesses, such as rape crisis, child advocates, and then you're going to have the general public, and you're going to have the media and students, retirees. You might have researchers there. So there's a number of different people that move in and out of the courtroom within a regular day's work, and that while it sounds like it could be really hectic, and at times it can be, in the same breath, it is much an organized chaos. The tone of the courtroom, even on very liberal courtrooms where the judge gives a little bit of discretion to behavior, even in those, it still is there is still you can see a measure of control by the judge in all the activities that are happening inside the courtroom. So, but as I said, when you have that many people, and you have a few people that do have authority and power, you're going to have conflicts as well. So we noted earlier that the judge is the key person in the courtroom. However, there are a couple other positions in the courtroom that also have power. You'll need to know these. All right. So the first one is the clerk of the court, and they're responsible, like I said, for docketing cases. They collect fees and fines. They oversee jury selection, the voir dire process, and the veneer. They also maintain court records. So there's quite a bit of responsibility. A lot of you have probably seen the clerk of the court. For those of you who have been into traffic court and had to go pay a fine as a result of a traffic violation, traffic citation, that's who you've met. You've met a clerk of the court. Now, typically judges are the ones that are responsible for signing off these cases, but the power of the clerk of the court allows them to do it. And in all but 6 states, they are elected officials, right? They're elected officials. So they do have a little bit of autonomy. They have authority, right? I don't know if you remember hearing about the incident where there was one, and I can't remember the state that she was in, that she was working for, the county and state, but she had decided that based off of her religious views that she would not give licensing, people requesting marriage licenses to individuals that were that were gay, and that was a really, really big issue. because again, she was a elected official, and ultimately they found her to be in violation of her responsibilities. But you can see that she had the power to stop people from getting marriage licenses. The other person that could be in conflict with the judge, and we talked about that person earlier, was the court administrator. So they're responsible for a lot of the HR stuff, annual reports, summarizing caseload data. They prepare budgets. They troubleshoot all the issues that are going on within the administration of the court. And they're generally, unless the employees are direct reporting to the judge, they would report to the court administrator. So some judges like to have a little bit more control, and that push-pull for power sometimes has caused some problems. So again, you'll need to know those three primary positions of power within the court. We said judge, clerk of the court, and court administrator. All right. Let me verify that I still have this going, because believe it or not, while I went through this entire chapter earlier and recorded this, none of it recorded. So I'm actually doing this again. I want to make sure that it is in fact recording and I'm not just talking to myself. So we talked about courtroom security and who actually presents or who provides the courtroom security. But there was a review by the U.S. Department of Justice back in 2009 that showed that 5,744 threats were made to federal judges and prosecutors between 2003 and 2008. So that's a 5-year span. In that 5 years, in a single year, nearly 300 threats to California state judges and their families were made. So, and I don't want to say that that's not uncommon or that's a common thing, but it isn't uncommon, right? I mean, it's not something that happens on a regular basis, but it does happen, and it's something that bears some, that there is some concern. And in 2010, the Center for Judicial and Executive Security released a study titled Court-Targeted Acts of Violence. That study encompassed 185 incidents of courthouse and judicial shootings, bombings, arson attacks, and that was between 1970 and 2009. And that study found the following. So this is pretty interesting information, and you will see this again. 86% of the courts did not have a security committee. So that's about out of every 10, 8.5. About 8.5 courts, 84% of the courts rather, didn't have any incident reporting system. So they relied, when there was an incident, a violation of law, an assault or whatever, they would have to rely on either sheriff and or police, whoever had jurisdiction in that, the incident reports for that incident reporting system. Although most courts did have security training for courtroom personnel, it wasn't specific courses for security staff. So, for security staff being able to gain compliance with a lawful order or to subdue a violent attacker, they didn't have that type of training for them, and that probably isn't a very good idea. Obviously, because you have a lot of people who could be very volatile. Imagine, if you will, an individual that had mental health issues, that was being put away for an extended period of time, felt that that it was a wrong sentence, and the likelihood is high that they could become violent and attack somebody within the courtroom. What's really kind of interesting is there is significant data that shows that one of the major recipients of violent attacks within the courtroom, most people think it'd be the judge, but believe it or not, it's the defense attorneys. Defense attorneys wind up getting the bulk of violent threats as well as assaults, because many what's the word I'm looking for? Defendants believe that they were railroaded. I mean, and you can kind of see. I mean, I'm not advocating for this, but imagine, if you will, you're relatively wealthy and you're defending yourself for a pretty serious crime. You're being charged with robbery, and you decide, well, I'm going to basically empty the savings and everything I've got, and I have a $75,000 retainer for one of the better attorneys, and I lose the case anyway. So a lot of people would say, wow, I spent $75,000 and I have nothing to show for it. So that would really kind of irritate some people. So defense attorneys do have, a lot of violence directed towards them as a result of verdicts and sentencing that happens within the courtroom. 92% of the courts had inadequate or no exterior closed-circuit television systems. Although most courts did have entry screening, a lot of them didn't have X-ray machines or wanding machines, and 1 in 4 had no screening at all. Right? So that's 25%. That's a significant amount. 55% of the courts had no security in the courtroom during courtroom proceedings, and we talked about that. In some cases, judges don't want to have law enforcement or any security in there with firearms, lethal use of force options, or less lethal use of force options. My personal opinion, I think that's a big mistake. It is, since I've been working, just FYI, here in Fresno, Madera County, for those of you who are going to be peace officers later on down the line, all the judges that I've had the pleasure to work with and under, I haven't experienced any of them who've asked to have me disarm when I was in court. So that was, kind of a godsend. But again, I don't want you to believe that is the norm. I really wish it was, but again, it's up to the discretion of the court, up to the discretion of the judge. And then 60% had personal alarm devices in the judge's chambers, and 96% in the courtroom. And the personal alarm devices, like in the institutions, they look about the size of a pack of cigarettes. They have a little button, and they're coded for sections. So when a personal alarm device goes off, the alarm goes, and you can tell where it's coming from. So that way you can have responding staff come and respond to the incident. Now, they also have, and some of the courtrooms have this as well, they'll have off-hook alarms. So when you pick up your phone and you dial out your extension when you're inside the courtroom, once you start your dial, you're good to go. But if there's no dial for, X number of seconds, say 20 seconds, then the alarm will go off. And because it's a specific phone in a specific area, they know where to respond to as well. So there'll be some courthouses have these off-hook alarms that will allow staff to respond in the event there is one. So something's better than nothing. All right. 3 concepts of the dynamic of courthouse justice. So you have to remember these, okay? So the first one is assembly line justice. The next one is discretion. And the next one is a courtroom work group. Okay, so all 3 of these. Assembly line justice is pretty much exactly what it sounds like, assembly line. Most of that is for low-level criminal behavior such as infractions and some misdemeanors. And it's done for a speedy and impersonal process where the end goal is to complete the case and not necessarily fulfill the obligations of due process for the defendant or defendants, plural. It goes hand in hand with routine administration. They're just processes of cases where a case is processed to disposition, and generally speaking, where there's no disputed question of law or fact to decide. And again, like I said, most of the time that happens during misdemeanor or infraction violations of law. When you get into felony violations of law, due process becomes much more relevant, only because these cases are generally seen by a secondary court, appellate court, and possibly more, and so the court is cognizant of that and makes sure that all the steps are followed to ensure that the defendant is afforded all of his or her due process rights. The next one is discretion. That's defined as the lawful ability of an agent of government to exercise choice in making a decision. And so there are 3 components: legal judgment, policy priorities, and personal philosophy. So an example of legal judgment would be the decision of a prosecutor to change or to file a charge with the court. So they can decide to do it, much like a police officer. If you see somebody jaywalking, you could write a citation if you wanted to, and you'd be well within the law. Or depending on the circumstance, if it's a little kid who's running across the street, you might want to go and admonish them, warn them, hey, that's not a good idea. You can get hurt, so on and so forth. And that is the discretionary decision that is afforded to agents of government. Discretionary decision by the court reflects policy priorities. So when a crime is committed, the prosecution must select how that will be charged to devote the correct priority to each case. And in that case, we're talking about how a set of circumstance may allow charging of 3 or 4 different violations of penal code or vehicle code or health and safety code or whatever. And sometimes extra legal factors are considered in that determination. And when they are considered, the prosecution has that discretion to do that. And now, generally speaking, they don't do it a lot, but they do have discretion to do it. All right, and the third one we talked about was the courtroom work group, and that's made up of all the participants in the day-to-day activities of the courtroom. So the primary ones we know are judge, prosecutor, as well as the defense attorney. And they interact based off of the norms of that courtroom work group. So the judge sets the tone, and everyone follows suit, and they know what the places are. We know that there's mutual interdependence and shared decision-making. Obviously, especially when you're talking about plea bargaining, you have individuals who are the prosecution, defense, or plea bargaining. They come to an agreement, but it's up to the judge to make a decision as to whether or not he or she wants to go ahead and allow that plea bargain to go forward if they feel justice is being served. The judge has the ability to say, no, I'm not going to accept that. That's not an appropriate plea bargain, and you guys need to go back. And I believe we need to address this, and this. So all of them have a shared decision-making responsibility within that work group. The older the work group, the more familiar they are. They have they're already socialized. New ones have to be socialized to the formal process first. Generally, that's how it works. These are the rules within the court, and then the informal process where you would learn the inner dynamics, the social dynamics of each one of these courtroom players, and be able to make adjustments. And if you make these adjustments well and you get along harmoniously, and we'll talk about some of the titles that they give certain types of work groups, and we'll get into that and more deeply into the work groups later on down the line. But if you what's the term? Go along to get along. Generally speaking, you're going to be rewarded informally. More of your plea bargains and more of your work is going to be accepted without major scrutiny by the judge or the defense attorney, or he or she might accept some mistakes and make the corrections for you, whereas ones who don't socialize well may be sanctioned, right? Well, you didn't turn this in correctly. You need to fix this, and you need to fix this, and this is crap, and that kind of stuff. And it does happen. So these courtroom players really need to kind of follow the judge's lead and kind of make a determination of how he or she wishes that courtroom to run, and work within that courtroom work group in order to get their work done as well. All right. Sometimes there are delays in court. We do have a right to speedy trial, Sixth Amendment right to the speedy trial, right? But for whatever reason, there may be delays, and a delay is referred to as an abnormal or unacceptable time lapse in the processing of a case. Now, there are 2 agencies, you'll need to know these, that have established time limits for case processing standards, and they are the American Bar Association and the Conference of State Court Administrators. So in the Conference of State Court Administrators, it appears that they're a little bit more liberal, or rather, they're a little bit more strenuous with their time delay. So for civil non-injury, they want them completed within 12 months. With injury, with the trial, within 18 months. And then for criminal felonies, completed within 180 days, and for misdemeanors within 90 days. The American Bar Association is a little bit more strict, and they're a little bit more, there's time markers for each different type of case. So on civil cases, they want to have 90% of it completed within 12 months, 98 within 18 months, and 100% complete within 24 months. And for criminal felonies, 90% complete within 120 days, 98 within 180 days, and 100% within 1 year. And then for criminal misdemeanors, 90% within 30 days and 100% within 90. So you'll need to know these time completions for adjudicating a case, and you'll need to know what some of the reasons why they do have delays and what a delay is. Okay, and the last one, speedy trial enforcement and legal ethics. So we talked a little bit about speedy trials, and obviously they're guaranteed by the Constitution, specifically in the Bill of Rights. The Sixth Amendment states, in all criminal prosecutions, the accused shall enjoy the right to speedy and public trial. So 35 state constitutions have speedy trial guarantees. However, it only applies to when the delay has been excessive, and that's been, that is to be interpreted by the court. In Betterman v. Montana in 2016, the Supreme Court ruled that the right to a speedy trial doesn't extend to the guarantee of a right to speedy sentencing after you've been convicted. Okay, so remember we talked about the different types or the different components to an adjudication of a case, and once you have the fact-finding phase and then you have the sentencing phase, fact-finding is what the Supreme Court determined is where your right to speedy trial exists. It does not exist to a right to speedy conviction. Okay. And then the Federal Speedy Trial Act of 1974 specifies 2 stages in the federal court process. 30 days is allotted from arrest to indictment and 70 days from indictment to trial. So there is some actual legal timelines, but that's specific to the federal government. Now, what are legal ethics? Legal ethics refer to the study and analysis of what constitutes good or bad faith conduct in the arena of legal professions. All right. So legal ethics govern how attorneys practice law, how judges administer justice, and how law enforcement operates in the course of their duties. Our oaths as law enforcement officers cover the idea of legal ethics. The American Bar Association is specifically for ethics in the court by courtroom actors. They're the ones who have adopted rules of professional conduct, which if any one of these attorneys, to include a judge, violates, they could lose their license to practice law. So, and the sanctions there can be pretty harsh if they're found to violate rules of professional conduct, which essentially would be violating legal ethics. All right, well, that pretty much covers the PowerPoints for Chapter 5. Again, if you have any questions, comments, or concerns, feel free to give me a call or an email. I'll be more than happy to take them. And we will see you again in Chapter 6. Have a good afternoon. Bye.